Honourable Member Hamdullah Sayeed.
For giving me an opportunity.
2 minutes.
Sir, 4 minutes. Thank you, Deputy Speaker sir, for giving me an opportunity to speak on CRPC Amendment Bill 2010. First of all, I would like to state that CRPC, which is a procedural law which authorizes the judiciary and the courts to deal with crimes and criminals. This law was enacted in the year 1973. When we talk about offences, briefly, the offences can be divided into two: cognizable offences and non-cognizable offences. Cognizable offences are those offences which are serious in nature and wherein the police officer does not require the permission of the magistrate to arrest a person who is accused of a criminal activity. And non-cognizable offences are those offences wherein the police officer requires the prior permission of the magistrate to arrest a person who is accused of a criminal activity. Therefore, these are the two basic offences which have been described in the Criminal Procedure Code. Schedule 1 of the Criminal Procedure Code, which is attached to CRPC, deals with the offences which have been given and which are mentioned. And we talk about Section 41. Section 41 of the CRPC clearly states that a police officer may arrest a person for a cognizable offence. Now, the person may be arrested if the police officer has suspicion or has credible information, or a written complaint has been filed against a person, or other than that, if the police officer in his presence, if the person witnesses the commission of an offence. If any of these conditions are satisfied, the police officer has the right to arrest the person. But the best part about this amendment is that the word may has been substituted with shall. Now, any police officer who arrests an accused person for a cognizable offence has to record the reasons in writing if he is arresting, and if he is not arresting, that also he has to exclusively mention in writing. He has to give the reasons in writing. So this is the best part about the criminal amendment, CRPC Amendment Bill 2010. Also, sir, Section 41A of the CRPC, which was inserted in the year 2008, which gives the authority to the police officer to summon, to issue notice to a person who is accused, and if the person who has been asked to come before the police station or to the police or to the SHO, and if he fails to come and comply with the conditions, the police officer has the authority to arrest the person. And this is again a commendable amendment that has been brought about, because, sir, 1 minute, sir, I am completing. So therefore, Section 41A and Section 41, both the sections in this the CRPC which has been amended is commendable. I would like to also state that Article 21 of the Constitution gives the right to life. The right to life does not only mean mere right to life. The right to life means right to life with liberty, with dignity, and with self-respect. There have been instances wherein innocent persons have been booked and they have been detained by the police, and their filing of charge sheet has been delayed, and even the interrogation and the trials, they are under trials. And if we see the number of the period of incarceration that they have completed in the bar, behind the bar, is more than the punishment that has been prescribed by law. Therefore, taking all these conditions into account, I would congratulate our Honorable Home Minister who has taken the initiative to amend the bill, and I would also request and urge him to take further steps to amend the IPC in the Indian Evidence Act and also the CRPC. Thank you, sir.
Thank you.